So you also mentioned about the reforms in technology, digital tools that the Supreme Court has been employing recently, and especially during your tenure as the Chief Justice of India. You were on it even before you took over, but it has been on a war footing ever since you have taken over. So when we talk about barriers to access to justice, how do these tools, technological tools, especially when we talk about barriers of language, comprehension, distance, there will be economical and physical constraints for somebody from a far off remote village in Kerala or someone from Gujarat to travel to the Supreme Court to attend his hearings. How do these digital and technological tools they come to the aid of removing those barriers?
I think the most important aspect of technology is that technology today and the technology which we have deployed in the judicial system is democratizing access to justice. And for instance, as a simple example, by making available video conferencing facilities to access the Supreme Court then ceases to be the Supreme Court of Tilak Marg, but it truly then becomes the Supreme Court of India. I'll give you an example of the state of Orissa. Chief Justice Muralidhar, who just retired, provided for accessing the seat of the High Court, which was in the capital, by having video conferencing facilities in every district opened up through which people could access the court. Lawyers from across the state could access the court. I have today lawyers from all over the country who access the court, and that results in a reduction in the cost of litigation. The lawyer in the districts, the lawyer in the high courts, is the first point of contact for a citizen who has a problem. When the case comes to the Supreme Court, they shouldn't feel disconnected from the process of dispensing justice. Technology is actually a game changer. I've spoken about translation, I've spoken about transcription of legal proceedings. We are in the process of now digitizing the entire record of the Supreme Court, which is almost over, of all the high courts. And the idea of doing that is to provide a transparent and accountable justice delivery mechanism to our citizens. We are implementing phase 3 of the e-courts project, which is a project of almost 7,000 crores for which the government has sanctioned funds to us. And the idea of phase 3 is to have a more citizen-centric judiciary. The colonial model of justice dispensation was that people must access our courts. That's why you have these very beautiful buildings, the colonial buildings, whether it's the Bombay High Court, the Madras High Court, or any other High Court, the Calcutta High Court, which sort of strike a feeling of awe in the minds of people. That model has to change, and we must be closer to our own citizens in terms of sending emails. I wouldn't bore you with the details or the statistics, but you would be fascinated to know the millions of emails which are sent by the court system to litigants who have cases before the court. We use WhatsApp. We are trying to communicate our orders, for instance, our bail orders to the jails. Very often courts grant bail, but that order is not implemented in the jail because the person for whom the order is meant is too poor to even get a copy of the order. Or he has to, or she has to then move all kinds of things before bail is granted. So we have developed a software called the Faster software in the Supreme Court, as a result of which our bail orders would be communicated to the superintendent of the jail in, say, Gonda, or Bharej, or Samastipur, or wherever in Maharashtra or Tamil Nadu. And the onus would be on the jail superintendent to inform the court as to whether the order was implemented. So technology in that sense is a great tool of accountability which we are using. We have the National Judicial Data Grid in India. The National Judicial Data Grid is a complete repository of all pending and disposed of cases. And we are increasingly opening up the space to private citizens, because I feel that we as judges should not be keeping all this data close to our heart. We must have open APIs so that people in the private space should be able to use the data which we are putting out, subject of course to concerns about privacy and security, for a more efficient process of dispute resolution in the courts.